There will be no surprises during your hearing. During the hearing, you will be asked a series of questions. The questions will largely be answered on a yes or no basis. I will ask you if you are the plaintiff in the matter in hearing. I will ask you if you were married to the defendant and state the date of your marriage. I will ask you the names and birth dates of children if you have children. The next questions will relate to the grounds for divorce. The grounds for divorce need to be stated on the court record. In an uncontested divorce, the likelihood is you have one of two options. Either you have irreconcilable differences that have arisen, which have caused the irremediable breakdown of your marriage, or you've been living apart from each other for a space of at least 3 years. You will be asked, do you allege that the grounds for divorce are irreconcilable differences which have caused the irremediable breakdown of your marriage? Or you'll be asked, are the grounds for divorce that you have been separate and apart from your spouse for a space of at least 3 years? Either way, those are grounds for uncontested divorces. I will ask you if there's any chance of reconciliation. You have to answer no to that question. And I will ask you if, despite all of your differences, you've reached an agreement. Once you reach an agreement and it's reduced to writing, the court doesn't need every detail to be reiterated on the court record, but they do need you to acknowledge that you have entered into the agreement freely and voluntarily, that no one coerced you into doing anything, that you believe it's fair and equitable. Also, the court will ask, through me and my questioning, if you want the court to incorporate but not merge the terms of your agreement into the final orders of the court. That doesn't sound very clear to most people when they first hear that question, but it's actually quite simple. It means your contract is a freestanding legal document that the court can enforce but not modify. In that manner, it is distinguished from regular court orders. Court orders can be modified. Once you have an uncontested divorce hearing and a full agreement reached, you don't want anything to change. And that language and that confirmation on the court record ensures that your agreement will be only enforced and not modified. Part of the court hearing requires that you be asked questions about alimony. An alimony waiver requires that you understand the concept of alimony as being support from your spouse, that you are able to convince the court, so to speak, that you are self-sufficient by stating you're self-sufficient, referencing your income or your source of self-sufficiency. For example, if family helps you out, that would be okay too. Also, you would be required to state that you are in good health, what your highest level of education is, and your age. When you hear those alimony questions, you know that your time in the spotlight is coming to the end, and the other party's turn to testify will be coming. When the other party testifies, they basically acknowledge and confirm that you testified accurately, and then they are asked the alimony questions. Seems like their side goes a little bit easier. So whether you are the plaintiff or the defendant, either way, it's pretty easy once we get to the court level. All of the hard work is done beforehand, reaching that agreement, negotiating the terms of the contract, and the bit of paperwork that's required to get us there. After your court hearing, you will hear a decision rendered from the judge. The testimony will be done, and you will essentially hear the judge reiterate all of the terms of your agreement, acknowledging all of what is before the court. It sounds very repetitive in the moment, but it's a very important part of the hearing. Once the judge says what is happening with your agreement is when it becomes a court order. But the work doesn't end there. Your hearing will end, and I will have some paperwork to do. I will prepare a decision pending entry of final judgment immediately following the hearing. It is a court order, and it is a temporary order in the sense that it is entered after the hearing, but it is not the final judgment. 3 months after the hearing, your final judgment is eligible to be entered in the court. I will prepare that document and submit it to the court for signature. When the judge signs that document is the moment in time that you become divorced. We will provide you copies of all documents along the way. You will have a digital record of your entire divorce proceeding. The documents that you will be provided include a copy of your signed agreement, a copy of a child support guideline worksheet if you have children, a copy of your decision pending entry of final judgment, and your final judgment. In the event you ever need a certified copy of your final judgment, as opposed to the digital one provided to you, you can obtain that at the Family Court Clerk's office. If you would prefer to ask me and my staff to help you get that final judgment in a certified version, then all you have to do is call the office. In fact, if you have questions at any point along the way, all you need to do is use the link on the website to schedule a telephone consultation with me. I look forward to working with you as we guide you through the uncontested divorce process.